Good evening. I'm delighted to welcome you all to Charles Claw House, the home of BIICL BICL, the British Institute of International and Comparative Law. Its independence, its breadth of expertise, its international network and its reputation and track record enable BICL to provide a genuinely unique and really important platform from which to address the most significant legal questions of our time. Through informing and influencing debate, legal reform and policy making, BICL makes a vital contribution to international security and prosperity. With the increase of repressive regimes across the world, impressively repressive regimes across the world, the effect of COVID, the war in Ukraine and other horrors, the need for BICL's work is greater now than it ever has been in its 60-year history. And it's therefore a heavy responsibility, as well as a great honor, to follow in the footsteps of the likes of Nicholas Phillips and Rosalind Higgins, who I'm delighted to see, both of whom are here tonight, Tom Bingham and Robert Goff as its president. BICL's Henry Weinrebe Memorial Lecture is held each year to honor the memory of a man who was a philanthropist and founder of the Dorset Foundation. The series of lectures focuses on the protection of international peace and justice, values which were at the heart of Harry Weinrebe's humanitarian activities. BICL, indeed all of us, have every reason to be grateful to the Dorset Foundation for its support for our international law activities for nearly 20 years now. That support's been critical in enabling BICL to expand its international law program, which delivers high quality research with far-reaching impact. It also has enabled us to set up an extensive program of events, the quality of which is evidenced today by the importance of the topic and the eminence of the 4 participants. But before I introduce the topic and the speakers, I'd like to thank our sponsor, Debevoise and Plimpton. On behalf of the staff and the trustees of BICL, we are extremely grateful for their support this evening and for other events and work we do. Turning to this evening's lecture, it is of course entitled Defending the Right to a Fair Trial. Although it's been long enshrined in international treaties and national constitutions, the right to a fair trial continues to be elusive around the world, with many governments using courts to punish their critics, stifle freedom of expression, and crush or at least marginalize human rights generally. So we have a topic which is very appropriate for our time. We also are very fortunate in having 4 speakers who are very appropriate for our topic. We have technically 2 speakers and 2 what are called sometimes discussants or commentators, but we will hear from them in turn. Chairs of events such as this frequently say that the speakers need no introduction. It's rarely true, but it does relieve the chair from having to do any homework. But on this occasion, it is true that none of the 4 speakers need an introduction, but a bit of background may be in order. Last year, the Oxford University Press published a magisterial 900-page Right to a Fair Trial in International Law by Amal Clooney and Philippa Webb. Amal has demonstrated a tireless commitment to the rule of law, and particularly recently the defense of journalists and the pursuit of war crimes. As an international advocate and advisor, teacher, professor, writer, public speaker, and benefactor, there is no one more qualified than Amal to talk on this subject. But there are 1 or 2 people who are equally well qualified, and one of them is Philippa Webb, who after an impressive 10 years in international legal practice has enjoyed an equally impressive legal academic career involving important publications, professorships at universities across the world, memberships of editorial boards of prestigious international journals. It's unsurprising that their book was received with widespread acclaim, including plaudits from people as eminent and knowledgeable as the former judge of the ICC, former UN High Commissioner for Human Rights, former Vice President of the European Court of Human Rights, and the current ICC Chief Prosecutor, to name but a few. The book was cited in the UK Supreme Court in the 2021 case of TN Vietnam, where its methodology was adopted, and it was described as disaggregating the right to a fair trial into a number of separate elements, such as the right to an independent tribunal, the right to prepare a defense, the right to adequate time and facilities to prepare a defense, the right to be present, the right to examine witnesses, the right to an interpreter, and so on. And last month, the American Society of International Law awarded the book its top publishing prize in international law for high technical craftsmanship and utility to lawyers and scholars. Turning to the two so-called discussants or commentators who will speak second, for decades, Baroness Kennedy has spoken up for, written about, and taken action on behalf of the rule of law and human rights, possibly more than any other individual in the United Kingdom. She was a successful QC, became a peer 25 years ago, and among an astonishing number of achievements, she's been chair of Justice and of the British Council, and she currently chairs the International Bar Association as Human Rights Institute. And the equally distinguished Lady Arden recently retired from the UK Supreme Court. She had an outstanding judicial career, and in addition to giving many important judgments, she chaired the Law Commission for England and Wales and performed an exceptionally active role in the international judicial world, giving many significant speeches. Fittingly, it was she who gave the judgment in Tien Vietnam, from which I quoted. So that, ladies and gentlemen, this evening is your panel, and I won't hold you back from them from any further and hand over to Amal.
Good afternoon, everyone, and thank you so much for being with us today at this event. I have to immediately share that this is the first time that Philippa and I have been in a room where we could actually do this. In case it's not clear, we're really excited about this moment. And we are also really honored that in addition to our absolutely formidable panel, we have with us today 3 former Supreme Court presidents, a former president of the International Court of Justice, judges from the Supreme Court, the Court of Appeal, the International Criminal Court, and the European Court of Human Rights, as well as my mum. So it's a particularly intimidating crowd. Since this event was announced in early February, the world has, of course, fundamentally changed. We have a war in the heart of Europe, and I'm now working, along with some others on this panel, on a legal task force on accountability that has been established at the behest of the Ukrainian government. The situation in Ukraine has, of course, put into sharp focus the fact that, as President Zelensky put it, the power of the United Nations Charter must be restored. As President Zelensky said to the UN Security Council, do you think the time of international law has passed? If the answer is no, then you need to act immediately. Philippa and I wrote this book because we see the potential of international law in helping to ensure the protection of human rights worldwide. And when it comes to safeguarding rights, safeguarding the right to a fair trial is a pretty good place to begin, because as Lady Arden has put it, a substantive right, such as the right to freedom of expression, is of little use if it cannot be defended by a fair process in front of an independent and impartial judge. The right to a fair trial is the right on which all others depend. It is at the heart of any civilized society. I thought about this over the weekend when I was reading about the first war crimes trial of a Russian soldier in Ukraine. There was an interview with the court-appointed lawyer for the defendant, the Russian soldier. And when he was asked to comment on the case, he said that this was his job and explained that, quote, "It is very important to make sure that my client's human rights are protected, to show that we are a country different to the one that he is from." That reflects the principled reason for writing this book. But more personally, My decision to write it was born out of experience of seeing not only how an unfair trial can ruin a defendant's life or in a death penalty case take it away, but also the devastating effect that one trial can have on an entire society. And I want to just provide a few examples. A few years ago, I had the privilege of working with Lord Neuberger on a case in which we were trying to get 2 Reuters reporters out of prison in Myanmar. The journalists had been writing a story about a massacre of 10 Rohingya men and boys in Rakhine State, where there was an ongoing genocide. They were on the verge of publishing their piece, along with photos of civilians kneeling before a shallow grave, when they were suddenly arrested. I was brought in by the then editor-in-chief of Reuters, Steve Adler, who explained to me that the journalists, while in prison, had been offered a deal: drop the story and we'll drop the case. They had refused, and they ended up being sentenced to 7 years in prison under the country's Official Secrets Act. They were convicted in a trial that was unfair in the most basic sense. Evidence had been planted on them by the police, and the conviction was based on the rationale that they had failed to prove their innocence. It took some time to get them out, and reporting like theirs had in the meantime stopped. It was clear that the case had led many other journalists to put their pens down. So I saw how one unfair trial can mean the end of a free press. In the Maldives, I worked on the case of Mohammed Nasheed, the first democratically elected president of the country. He was known as the Mandela of the Maldives, but then one day was ousted from office. He was then arrested, dragged on the ground by police, charged with terrorism, convicted, and sentenced within 3 weeks. Although the trial proceedings were patently unfair, and just to pick a couple of many examples, 2 of the 3 judges had been witnesses for the prosecution and prevented Nasheed from calling any witnesses in his defense. He was sentenced to 13 years in prison. This prevented him from running in the presidential elections, which was, of course, the goal. And as he was the last remaining opposition leader who was free, this completed the government's plan to make the elections a foregone conclusion. So I saw how one unfair trial can mean the end of democracy. A final example comes from the Middle East. I have over many years represented Yazidi victims of the genocide committed by ISIS in Iraq, mostly women. While we have had some success in seeing ISIS members put on trial in Germany and in the United States, most ISIS fighters have either never been put on trial or have had a trial in Iraq, where the UN has said it has, quote, serious concerns that basic fair trial standards are not being respected. Yet the victims tell me that they want ISIS to have a real and fair process. They want nuanced proceedings and nuanced charges and open proceedings and the use of forensic and witness evidence, not the rush to executions that we see in Iraq today. So I have seen how unfair trials can devastate a community of victims as well as defendants in criminal proceedings. Now, although these examples involve politicized prosecutions and conflict zones, the research for our book uncovered that the deck is stacked against defendants, even in ordinary criminal trials, to a degree that is staggering. In China, Israel, and Russia, the conviction rate in criminal trials is higher than 99%. In China, it's actually higher than 99.9%. When the CEO of Nissan, Carlos Ghosn, was arrested in Tokyo, we got an insight into the system in Japan, which also has a 99% conviction rate, and which a UN representative has called medieval. And in the United States, the conviction rate is over 90%, but with more than 97% of convictions resulting from guilty pleas, meaning there is no trial at all. The common thread that runs through these cases is the relevance of international law. Almost all the states I have mentioned, and indeed more than 170 states around the world, have ratified the International Covenant on Civil and Political Rights, the treaty that guarantees fair trials. And our book argues that the right to a fair trial and its core elements have reached the status of customary international law, which means that even states like China, which haven't ratified the treaty, would still be bound to respect the same standards. Many states also recognize the jurisdiction of international bodies that can grant relief for violations of these rights. For example, the Maldives recognizes the jurisdiction of the UN Human Rights Committee. Russia has for years faced claims before the European Court and will still face claims for a few more months. And all states can be subject to claims before the UN Working Group on Arbitrary Detention. So we see in international law an opportunity to ensure that minimum standards of protection are respected across the globe. But if international law is to play this role, it needs to be accessible. So this book explains what Article 14 of the International Covenant means, comparing it to the equivalent provision in other treaties, and assessing how each of the provisions have been applied by international bodies, including the United Nations, regional human rights courts, and international criminal courts. It explains through an analysis of cases what the right to adequate facilities for a defense really means, what limits there are on the right to choose counsel if you're not paying for it, when prosecutors may refuse to disclose evidence in the name of national security, or when a court can hold proceedings in the defendant's absence. We distill and compare what each international body has said about these issues. And overall, the answers have been surprisingly consistent, with also quite significant cross-referencing between the bodies. So it is our hope that with the assistance of this book, lawyers are better positioned to invoke the minimum standards in courtrooms around the world. Because if lawyers don't raise them and then judges don't apply them, the opportunity for greater protection is squandered. We hope that our book can help to crystallize and codify what it means to respect the rule of law. We hope that law students and professors will make use of a textbook that for the first time deals with this important right holistically and in practical terms. Most importantly, we hope that our book will be used to defend human rights in the police precincts and prisons and courtrooms around the world where it is most needed, so that we can contribute to the fight for justice, one case at a time. Thank you.
Good evening. It is such a pleasure to have an in-person occasion for our book, and it is a privilege for this occasion to be the annual Harry Weinrebe Memorial Lecture. We are delighted to see so many friends and colleagues, and to have our research team, all of them brilliant lawyers themselves, Vera, Kat, Sam, Julia, and Nadine with us as well. As Amal explained, the book was a codification exercise. We analysed the key international sources of the right to a fair trial and distilled the minimum standards. But this exercise can also help us address upcoming challenges to justice and the rule of law, such as the growing use of technology and artificial intelligence in criminal proceedings. In a recent review of the book, Lady Arden noted, advances in technology may lead to discovery of new aspects of the right to a fair trial. They may lead to new questions and topics. For example, it may be that in the future, there will be not just a right to examine witnesses, but a right to interrogate digital evidence. Amal mentioned the distinguished audience here tonight, and I would note that my high school debating coach, Andrea Coomber from Australia, is here, now head of the Howard Penal League. And so I will keep to time and make 3 points. First, lessons from the pandemic. Second, the challenges of digital evidence. And third, the challenges of artificial intelligence. And the standards that we explore in the book provide a basis for analysing and meeting these challenges. First, the pandemic. We have just been through a 2-year, massive, largely unplanned experiment in realising the right to a fair trial in the digital space. Defendants and witnesses appearing by video link, counsel making submissions from their living rooms, judges presiding from home offices flicking through electronic bundles, and the public following proceedings online. And it is striking that as the pandemic made in-person trials dangerous to public health, only Estonia and Georgia expressly derogated from the right to a fair trial in Article 14 of the ICCPR. But it is not enough to conclude from this practice that the right to a fair trial can be realized in the digital age. As Lady Arden and now Lord Neuberger have noted, we need to disaggregate the right into its 13 component parts, some of which adapt well to digitalization and others which raise some concerns. A virtual hearing can satisfy the right to a fair trial, but it requires careful implementation. The component right most obviously affected by a virtual hearing is, of course, the right to be present. In human rights law, that right generally requires that the defendant has the opportunity to be physically present in the courtroom. The Human Rights Committee referred to the opportunity to personally attend the proceedings, the European Court to personal attendance of the defendant, and the Rwanda Tribunal to physical presence contrasted to facilitated presence via video link. But even before the pandemic, the right to be present could be satisfied in some circumstances by a virtual hearing. The European Court specified that the use of video link must be compatible with the requirements of respect for due process. The defendant must be able to follow the proceedings, to be heard without technical impediments, to have effective and confidential communication with a lawyer. This brings in the component right to counsel. And the use of video link has helped mitigate violations of another component right, the right to be tried without undue delay. Because even though courts have faced a major backlog in cases during the pandemic, at least some progress has been made possible through virtual hearings. The Crown Court backlog increased by 48% between March 2020 and June 2021. But the use of virtual hearings increased capacity to hear cases by 30% during that period. I've mentioned the potentially negative impact of virtual hearings on the right to counsel, but video appearances also lack the relational part of in-person interactions. Studies show that up to 93% of our communication is non-verbal, and this affects trust, credibility, and clarity. And this in turn affects the component rights to prepare a defense, to examine witnesses, and even to be presumed innocent. To give you an example, Alnur Ilyashev was a human rights activist in Kazakhstan convicted of spreading knowingly false information during an emergency, during the pandemic. His trial was monitored by the Clooney Foundation for Justice's Trial Watch program and was given a grade of D on an A to F scale based on compliance with international fair trial standards. The severe violations included repeated technical problems with the video feed that prevented Ilyashev and his counsel from making motions or questioning witnesses. He was also unable to consult with his counsel on a secure line. The presiding judge took no steps to remedy these violations. And in the trial observation report, the following surreal exchange was recorded. The judge shouted, "The court can see and hear you all." The prosecutor shouted, "The prosecutor also can see and hear everyone." The defendant shouted, "I cannot hear you." Then all participants and journalists were disconnected from the hearing. My second point is the challenge of digital evidence. Digital evidence is already a feature of our legal system. A 2020 report by the National Police Chiefs Council found that 90% of criminal investigations now have a digital element. And this brings great potential. Photos and videos of criminal behavior by Russian forces have been uploaded to dedicated websites. Ukrainians are documenting damage to their homes. They are geotagging and timestamping footage in the hope that it will one day be used in court. And facial recognition software has already been used to identify ISIS fighters and Russian military officials in photos. But there are challenges, including authenticity, because the original creator may be anonymous, reliability, because of the risk of this material being forged or manipulated. The huge volume also makes disclosure and discovery difficult, and the nature of the evidence may require technical expertise. And we've also seen miscarriages of justice based on a flawed approach to computer evidence. Between 2000 and 2014, more than 700 post office branch managers were convicted after the post office computer system Horizon falsely showed shortfalls in accounts. They were prosecuted for theft, fraud, and false accounting. Some went to prison, others lost their livelihoods and their homes, many went bankrupt, and some died before their names were cleared. And these trials were deeply problematic. First, independence and equality of arms were compromised. Here was a large organization acting as investigator and prosecutor of alleged crimes in which they were also the victim. Second, as our book explains, the right to prepare a defense includes the right to receive information and evidence. The workers were asked in court to identify the flaws in the computer evidence, but without proper disclosure from the post office. And key evidence, including the knowledge that this was a systemic issue and that there were balancing errors in the system, was not disclosed. And third, belief in the reliability of digital evidence essentially reversed the presumption of innocence, a component right that our book calls a prerequisite for any system based on the rule of law. In 2019, the High Court found the Horizon system was not remotely robust. And last year, the Court of Appeal said the prosecutions were an abusive process and an affront to justice. And now to my last point, the challenge of artificial intelligence. In 2018, Chief Justice Roberts of the US Supreme Court was asked, can you foresee a day when smart machines will assist with courtroom fact-finding or even judicial decision-making? And he said in 2018, it's a day that's here, and it's putting a significant strain on how the judiciary goes about doing things. Artificial intelligence can analyze massive data sets at speed and use the results to apply rules consistently and to predict outcomes. It doesn't get tired or hungry or grumpy. It's already being used in diverse contexts for case analysis and prediction in the US, China, Estonia, Brazil, Argentina, and Colombia. But we've also heard about the emerging problems, evidence of racial, gender, and social bias in the algorithms, lack of transparency, difficulty with contextual and balancing reasoning, and the ethical implications of delegating public authority to the private sector in the form of a machine. Lord Sales of our Supreme Court has observed, algorithms may not capture everything of potential significance for the resolution of a human problem. And the psychologist Mandeep Dami has reported on the view of criminal offenders that she's worked with. And they say, even knowing that the human judge might make more errors, the offenders still prefer a human to an algorithm. They want that human touch. And we can also see this through the lens of the right to a fair trial and the component of a competent, independent, and impartial tribunal established by law. There's already been decisions not on AI, but on the problems caused by faceless judges, such as in terrorism trials. And these have been condemned by the Human Rights Committee and the Inter-American Court. International human rights law has emphasized that biased decision-making must be identified and remedied through careful human review of the trial record. The use of AI therefore also raises concerns around the right to appeal and the right to equality before the courts. So I return to Lady Arden's suggestion that technology may uncover new aspects of the right to a fair trial. This is an area where new digital rights may play an important role to safeguard existing rights. And there are already calls for a new right not to be subject to an automated decision. And it may be that we could do with robot legal assistants and paralegals while retaining our human judges and juries. So in sum, the component rights that we unpack in the book will be essential for upholding the rule of law in the digital age. As we learn from the pandemic, we address digital evidence and we work with AI. Thank you.
Well, we've just had two excellent speeches from talks from Amal and Philippa, and we now move to Helena.
Well, you're not going to get a talk from me. I just wanted to explain to you how this has come to play a part in my life, because we were involved in the launch. And when these two fabulous women described to you how this is the first time they've been in a room where they're able to hold up their wonderful volumes, is because the launch had to take place, of course, during COVID. And the International Bar Association's Human Rights Institute hosted the event, and it was our privilege to do so. And one of the reasons why is because this book is going to be fundamental in many of the training programs that we run around the world, training lawyers in how they can make use of international law, often because the principles are the same if they use them in their domestic environments. But it also means that they can take cases to international courts and to develop their skills and capacity to do that. Now, we all know that the right to a fair trial is one of those fundamental core principles with regard to the rule of law. When I became the director of the International Bar Association's Institute of Human Rights, one of the first things, of course, new arrivals always do is that you look to see whether the work that's being done might be readjusted and whether there should be a different kind of strategy. And it seemed very clear to me that a number of things were happening. We were seeing a sort of global shift, and this was even before the pandemic. There was a different kind of pandemic taking place with regard to populist authoritarian governments being rather slipshod about trials and about the protection of the rule of law. And so a lot of our work is around calling out failures to protect the rule of law, ways in which governments are sort of retreating from the rule of law, and a serious retreat is certainly, all of you will know, is taking place. And so one of the priorities had to be about protecting lawyers and judges at risk, but also about building the capacity of lawyers everywhere in how to make use of the international courts. But it was wonderful when Amal and Philippa put together this incredible volume, and I really recommend it to all of you, because I was a domestic lawyer until taking on the role of director, and now it sits on my desk and I'm regularly thumbing through it and making use of it. And so I just wanted to talk to us and remind you of a number of the things that we've been involved in over the recent past. Let's just think about the failure of justice in the Khashoggi case, the murder of a journalist in Turkey. I happen to have been involved in the investigation of that with the UN rapporteur, and I saw up close what the nature of that evidence was with regard to that murder. I heard the intelligence and was privy to the evidence that there was with regard to where that murder conspiracy had come from. And all I can say to you is that what took place was by no means a fair trial. And we've now had, even after Turkey insisted that they would hold a trial even in the absence of those who had committed the offences, that has now been sacrificed too in relation, because some sort of deal has been done between both Turkey and Saudi Arabia, neither of which are well known for being great protectors of the rule of law or fair trials. But that was one of the things that started off my work around these issues. And I'm not unfamiliar with miscarriages of justice. I was involved, as many of you will know, in Irish trials where there were serious miscarriages of justice. I acted in the Guildford 4 and in part of the Birmingham 6 case. I was involved in the cases involving mothers who were convicted of killing their babies when they're in fact miscarriages of justice had taken place there. And of course, we've seen more recently the whole business of the post office workers convicted of fraud and how terrible the toll was on the lives of those people wrongly convicted. So fair trial is fundamental. But we've just had Paul Rusesabagina. Here we are about to send our folks off who arrive on these shores seeking a sanctuary from persecution. And we're going to send them off to Rwanda, a place that, again, not well known for its protection of human rights and certainly not in relation to fair trial. Paul Rusesabagina who was a critic of Kagame, the current leader, was kidnapped in Dubai, transferred to Rwanda, put on trial, and it bore very little relation to what we would consider fair trial processes. And it's a scandal that we are probably going to hold the Chogam Commonwealth event there in Rwanda, and that we're going to expect it to be a place where we process people who are being criminalized because of the way that they've arrived on our shores, even if they've been persecuted. Alexei Navalny, the whole business of Russia and the poisoning of Navalny, a leader of the opposition, and the fallacy of a trial that's taking place there, and with Amal, and we're involved in a seeking at a distance to do a trial observation, trial watch in relation to his lawyer was also arrested and has been called a foreign agent. And that's another thing that happens, is that in order to deny and to have a chilling effect on the legal systems, people are, the lawyers end up getting arrested too. And that's certainly true in Turkey, it's true in Russia, it's true in many of the places in which we are actively involved. Nazanin Zaghari Ratcliffe, that whole business again of using kidnapping as a way of in the business of foreign affairs, and certainly she did not have anything that could remotely be described as a fair trial. And we also know, I mean, we've been doing a distance review of the trial of Aung San Suu Kyi, and we tried to get access. The COVID was used as an excuse for not allowing anyone in to do international observations of the trial. And then we had, I wrote to the Chief Justice, I wrote to the prosecutors, I wrote via our own embassies to see whether we couldn't have live streaming of the trial, but apparently live streaming hasn't arrived in Myanmar. But, and so again, unable to see what goes on, and the lawyers complaining that they've not had access to the papers, not able to cross-examine people properly, not able to have proper time with their clients. That was also true in the Rusesabagina case. And then I wanted to mention it to all of you, Osman Kavala. Osman Kavala might not be known to many of you in the room, but Osman Kavala was a great pro-democracy person in Turkey, was the chairman of Open Society, which of course was being vilified by Erdogan. And he has just recently been convicted and given a life sentence. A man who I can assure you, if we sent out an observer to the trial, and we were obstructed at every turn. And I regret to say that what took place, again, was a travesty. And yet, of course, the problems of trying to have these matters taken up in international courts, because we've seen a retreat from and respect for the international order that has been so important in the post-Second World War period. That is all, that sort of commitment to that order has been trashed. And it should be a source of real concern to all of us. So, I mean, I want to pay tribute to the editors of this set of books, because they really are tackling one of the fundamental areas where there is an abuse of human rights. And I want to remind everybody that Tom Bingham, in his wonderful little book on the rule of law, speaks about how fair trial is fundamental, and how the making of laws, how it should take place to conform to the rule of law, but also reminding us that in the modern world, the protection of human rights is part and parcel of the rule of law too. So that was all I wanted to say. And I want to pay tribute to you both, because it's a great feat. And let me tell you, their husbands are going to divorce them if they try to rewrite it anytime soon. So that's definitely, and I'm going to have to make sure that I mediate in all of that. I've made a commitment to both of them, both their men, that they will not be reviewing it any time very soon. No.
Just before I hand over to Mary, let me say that we will have time for questions afterwards. Normally, people watching remotely are at a disadvantage, but they are at the advantage in the sense that there are questions already coming up on my screen. So please if you're physically here, feel free to ask questions in due course. But let me hand over now to
Mary.
Mary.
Yeah.
Oh, she's got it.
Yes, she has. Is it up and running? Try.
Could I say good evening to everybody and thank you for listening. We've had an absolute cornucopia of points about the right to fair trial. So I think what I'm going to do is not mention any specific cases, but just pull out one or two points which might form the basis for some discussion if there are not enough questions already. First of all, it seems to me that we must remember that the way to get things changed and to get better respect for fair trial is by remembering that the process of producing change is multi-layered. Of course, we want leading judgments in the domestic courts, and of course we need judgments in the international courts and in the committees such as the UN Human Rights Committee. But we also need NGOs, people who will go out there and put pressure on the necessary parties continuously, and also pressure on countries to become a party to relevant international conventions. And then we must not forget, particularly as mention has just been made of Nazarene Zaghiri-Ratcliffe, the role of diplomacy in all this, the very difficult tasks which diplomats have of progressing individual cases and how important it is that they do so. The second high-level point I just wanted to make was that what we've heard this evening makes it perfectly clear that the right to fair trial is an ongoing matter. It's not simply a case of being able to write a book and say, we've done it now. We've already heard about several challenges: COVID, digital evidence, and also a number of cases of kidnapping and so on. The method of challenge will continue to develop, and therefore we have to keep an eye on the principles and continue to work in terms of principles and make sure that they are complied with and are seen as adaptable and adapted to current challenges. And the last thing is, please never underestimate institutional safeguards for the rule of law. And I say this particularly as a judge. Judges have got to have sufficient resources to have the courts in which to see that a fair trial takes place. They have to be totally independent and free from pressure. And I have seen in recent months, even in this country, challenges to the independence of the judiciary, and indeed challenges to the advocates who would present cases. For instance, we had a case about same-sex marriage recently, and counsel for the winning party, because it was about a ban on same-sex marriage, was pilloried by the students of the university where she is a head of house. So the challenges come thick and fast. All I can say, again, because I want to be brief, is this book is going to help you greatly. I congratulate the authors, and particularly on their recent award of the ACIL Book Prize. That's tremendous. And I thank also the chair and the members of this panel for making it such an interesting discussion so far, and I'm sure it's going to get even richer. And Bickle, and also I want to say a special thank you for Dorset Foundation. I've been associated with Bickle over many years, and I am well aware of the magnificent support which they have given, which I hope will continue.